And, Chair, what we also note Mr. White's evidence where he said it's quite common to have threats against the police. But the submission is that the number of threats and the ferocity of the threats was exaggerated by the police. So why would they do that? Why would the evidence that seems to be undisputed that there were threats made against the police, why would you need to exaggerate these? And what the SAPS does is it says there were threats, there was an attack or a perception of an attack by the police in the TRT line. So therefore the strikers have followed through on their threats. But, Chair, that's simply illogical and doesn't flow, because the same logic could be applied to the police. There's evidence that the police intended to use lethal force. They used lethal force. Therefore, they had a premeditated intention to kill strikers. These simply do not lead to those conclusions. In addition to that just completely fatal flaw in logic, we then have a part of the SAPS case that is deeply objectionable, and it's addressed at Part 4, Section 4.5 of our heads of argument. And this relates to the use of Muti, because Muti seems to be the answer for the strikers' conduct for the police. And, Chair, simply, the use of Muti does not establish a shared, common intention by the strikers to attack police. But we make further submissions with respect to the use of Muti. The first of these is that the evidence before this commission on Muti that can be accepted, because Mr. X's evidence ought to be rejected in its entirety, the evidence before this commission is that Muti was used. We have the photographic evidence of it. We have oral evidence of it. We know from the post-mortem reports that a number of those killed had fresh scarification marks indicating Muti use. But, Chair, we also have evidence that should be accepted by the Commission that the Muti was for defensive, not offensive means.
Why was Mr. Fundi's body mutilated?
Chair, we have no idea.
I could understand herbs being used and water being used and Muti of that kind to, as apparently some professional footballers use it week in, week out. Even if they've lost last week, they still use it again this week. I can understand that. And that's effectively the level of Muti that you're conceding was present. But Muti involving, now, well, one mustn't take two steps in one. Why was Mr. Fundi's body mutilated? For what purpose? That's a fact that we can't ignore. His brother, who prepared the body for burial, made an affidavit about it. Also, some post-mortem evidence about the body as well. Not as clear as the brothers, but nevertheless. Why was the body mutilated? For what purpose? Why were those portions of the body removed? Why? What for? If it was, if the next step would be, if the argument presumably would be for the police, it was for the purpose of making Muti. What sort of Muti? Quite powerful Muti, surely. Not the kind of Muti that footballers use on a Saturday morning before they go to the football ground.
Chairperson, I'm sorry, I don't want to interrupt, but there's no evidence that any body parts were removed. That must be, I think Commissioner Hemraj tried to explain that yesterday.
I put to you what the brother who made an affidavit, who prepared the body before burial. He said parts of the body were removed, around the mouth and so forth. That is the evidence. Anyway, Mr. Puffy, you'll get a chance to speak later. I don't want to encourage counsel to interrupt other counsel, even if they're intending to assist the counsel presently arguing, because that way leads to a lack of, what is the word, command and control.
Yes.
And I don't want to be criticized on that ground.
Thank you, Chairperson. Now, I was assisting the Chairperson.
All right. I suggest you carry on, Ms. Rue.
Thank you, Chair. And, Chair, we have two answers to the question, why was there this mutilation of the body, if that is what the evidence that's accepted by the Commission shows. The first answer is we simply don't know. There is no evidence before this Commission that explains the purpose of that, if it in fact happened. So this Commission does not know why. Secondly, even if we accept that it was to strengthen the Muti that was used by the striker, somehow make it even stronger and more powerful, that does not establish a common intention to kill policemen.
that's a separate question. Yeah, I haven't got a problem with that.
But, Chair, that is where the police use Muti. The police use Muti to explain somehow, magically, a common intention is formed by the group of strikers. The evidence before this commission does not establish that.
Well, aren't they entitled? I'm just putting this to you as something to deal with. I'm not sure what the answer is, and I hope I will be sure by the time we write our report. But the argument on the other side, I imagine, would be that if you can use the removal of some parts of the body as an indication of, and there's no other reason to suggest itself, to create powerful Muti, and then one can look at the bodies of those who had scarification marks. The argument would be that this wasn't, footballers don't, as I understand, don't normally have scarification marks every Saturday before they go to the football ground. So the argument would be that at least those people took it for took that particular Muti for a particular reason, and that would, it may not take them all the way down to a conclusion that there was a common purpose, but it would indicate some kind of common mind at the stage of the scarification. Well, that's a matter I take it that Mr. Semenya, if he thinks there's any substance in the point, will elaborate on, and when he does it, we will obviously ask him questions directed from the other side to test the accuracy of any submissions he may make in that regard.
But, Chair, at its highest, what the evidence before the Commission, and I must pause to just say that Muti and the Commission must be treated not as something exotic or magical or a feature of the occult or anything like that. It is a perfectly ordinary, regular practice by South Africans. And the evidence before the Commission is what we should be concerned about and what it shows us, not some prejudice that we may have about its use.
Colonel Vermaak also gave evidence based on his experience as a public order policeman dealing with unrest elsewhere in the Northwest Province. And he gave evidence about Muti and the use of Muti in circumstances of public unrest. So it's not correct to say that there's no evidence at all. You may say that there are questions regarding the weight of that evidence. You may also be met with the point that that evidence wasn't challenged in cross-examination. But it's certainly not correct to say that there was no evidence at all.
No, Chair. My submission is that there is no evidence that Muti creates a common purpose, a single intent. The use of Muti is not disputed. And in fact, as far as I read the evidence, Muti was used in order to embolden the strikers. It was used in a ritual where they joined together and felt solidarity defensively against the NUM initially and then against the SAPs. That is the evidence before the Commission. That does not take the police to where they want to go with Muti, which is that it establishes single intention to attack the police, justifying the use of force at scene 1.
Making the point, perhaps I should put it to you as well, in relation to the suggestion which is put up by the strikers that they carried their weapons to defend themselves against NUM was a response to the shots that were fired on the Saturday morning. That evidence has a serious question mark over it because firstly we have evidence of intimidation and so forth from starting the Friday night. Secondly, we have evidence that they went to the NUM office with arms. Direct evidence was given by one of the NUM witnesses who wasn't cross-examined on the point. The evidence is the attack on the NUM office was about 11 o'clock. They started buying weapons at 9 o'clock. So one certainly cannot, without more, accept the suggestion that they were bearing weapons simply to defend themselves against an attack from NUM. There is evidence which points the other way. It's all obviously got to be evaluated. The final decision can't be made until the very end. It's something that is on the table and has to be examined.
Chair, I'm not sure how to respond to that because obviously we've addressed what we know in the evidence in terms of weapons carrying and the like, and as I've already said, we accept that the strikers were armed and in their ranks may have had violent individuals. But again, as the use of Muti doesn't establish common intent, nor does carrying weapons. That's the point I'm dealing with.
I wasn't dealing with that. I was responding to the submission you made, or the comment you made, that the evidence of Muti that we have may well be explicable on the basis that they wanted to be emboldened so as to deal with an attack by NUM. I suggested to you that that might be contended to be an oversimplification in the light of the facts I put to you.
Chair, if I can return then to the evidence before you about Muti, a critical piece of evidence is that of Professor Lumler, and the SAPS put in a supplementary statement by him the last day of hearings that we were here. Chair, this is addressed at page 154, paragraph 4.5.11 of our heads of argument. Because what is striking about the SAPS's own evidence, the SAPS's expert evidence on Muti, is no higher than that the Interlazy would have galvanized the strikers into action to allow them to die for a noble cause and confront the inevitable with fortitude. Doesn't say they think they're invisible, doesn't say they think they're invincible, just says they are galvanized and they will bravely confront the inevitable with fortitude. So, Chair, obviously we don't accept that the strikers would have had some intention to die, but the SAPS's own Muti expert has disassociated himself from the SAPS case. He does not say the use of Muti either created a common intent to go and attack police, or that the belief was that they were invisible or so invincible and sought out an attack against the police. But in addition to the expert evidence put up by the police, which doesn't help the case that they make relating to Muti, we have the objective evidence, which shows us strikers wearing large blankets to protect themselves from rubber balls. If they believed that rubber bullets could hit them, why would they have thought they were invisible or invulnerable to sharp-pointed ammunition? The strikers were blocked by Nyala Fall when they were trying to walk down the road in Canets before running towards the TRT line. If they'd already been hit by these rubber bullets, why would they still continue to believe that live ammunition would not harm them? And finally, the strikers that retreated to the third Kopi are alleged by the SAPS to have been part of a core group that initially attacked at Scene 1. If they'd seen their fellow strikers shot and killed by the police bullets, why would they continue to believe that they were invulnerable to sharp-pointed ammunition at Scene 2? So, Chair, the evidence before the Commission relating to the effect of the Muti simply does not establish the police case of a common intention to attack the police that would justify killing them at Scene 1 or Scene 2. Chair, this notion of, it has a lot of alliteration in it, but essentially the notion that you would have, murderous miners on Muti attacking you is just not the evidence before the Commission. Chair, in a similar vein, and this is dealt with at Part 4, Section 4.6 of the Heads of Argument, the conduct of the strikers, the crouching and clanging of the weapons that we heard so much evidence about, similarly does not establish a common intention to kill police. It doesn't even establish an individual's intention to attack the police. But, Chair, what all of this ultimately boils down to is that the SAPS case about the common intention, the shared intention of the strikers, comes down to a deindividuation theory, which is not only wholly discredited and without support in modern crowd psychology theory or literature, but is contradicted by the evidence of the movement of strikers. We deal with this in Part 4, Section 4.7 of our Heads of Argument. So, Chair, we see the splitting of groups of strikers. So if that group of 300, when they set off, shared a common purpose, they were shedding membership all the way around the kraal. We know from the video footage that strikers turn away. We know from the positions of the bodies around the kraal that strikers were not continuing in their movement towards the TRT line. So even if de-individuation could provide the answer that Muti and clanging of weapons can't provide, it simply cannot be accepted by the Commission. So, Chair, to sum up then what we know happened in the lead-up to Scene 1, we now have a disavowal of Incidents 1 and 2 by the SAPS. We have an acceptance by them that the group splits. And, Chair, I must be clear that I don't misrepresent that acceptance by the SAPS legal team. They accept that the group splits and some people turn and run away. It's not clear that the SAPS accepts the further splitting around the kraal into the little groups.
Basically the two groups, the lead group, I think it is, and the kraal group.
Correct, Chair.
I think they call the edge of the
kraal edge group and the lead group. Yes, Chair.
Well, let's find out. Semenya, are you able to answer that? Do you accept that there was that splitting? Because if you do, then that will shorten things.
I accept the video footage is what it is, Chair. Whether that is a split or not a split, it's a different matter.
I see. All right. Okay. Thank you. You've heard what Mrs. Semenya says. So you're going to have to go. You have to go the long road, not the short road.
And Chair, Mr. Chaskelson has dealt with what the video footage shows, so I'm not going to duplicate that effort. But Chair, what that objective evidence showing movement of strikers then brings us to is the questions of proportionality of the shots fired at scene 1 and the approach that the Commission should take to those. This is set out in Part 10, Section 7 and Part 4, Section 3 of our heads of argument. Chair, a number of submissions arise. The first is that the evidence before this Commission from the SAPS is woefully inadequate to justify shooting either being necessary or proportional. There is no evidence before you to justify the continuation of shooting, we would say certainly beyond the 4 seconds when the dust cloud arises, and in addition, beyond the first calls of ceasefire that are made within 4 seconds.
Remind me of that. The dust cloud seems to arise after about 4 seconds, and the ceasefire call seems to be also at about 4 seconds. Are we able to see, sometime since I looked at the video, are we able to see with a fair degree of certainty that the calls of ceasefire more or less coincided with the beginning of the dust cloud? Then
Yes,
if
Chair.
so, you can take the two together and say those were two reasons, self-standing reasons, but there's a synergistic effect of the one on the other, which would strengthen the case for saying that there should have been a cessation of firing when those two things coincided.
Chair, the dust cloud and the calls for ceasefire coincide at 4 seconds. The dust cloud is what you see on the Reuters footage. The calls for ceasefire are on the Al Jazeera footage, which has a different field of view. But on the timing correlation exercise, they coincide at 4 seconds. But of course, Chair, recall that the submissions made by the Human Rights Commission with respect to ceasefire, which is that this is a contradiction in the SAPS case, because ceasefire should be irrelevant if you're shooting in self or private defense. You stop shooting when you have neutralized the threat that you are responding to. So the dust cloud obscures that threat, and you should have stopped firing. The fact that it coincides with a ceasefire call as well is a separate point which contradicts the self or private defense case advanced by the police.
I'm not sure that it contradicts it exactly. Let's assume that each individual shooter is entitled and almost obliged to make up his own mind as to whether it's necessary to shoot in self-defense. But if an officer then thinks that whatever the situation was when the shooting started, the danger is now over, there's nothing to stop him from saying to the shooters, stop. It's clear to me that whatever threat there may have been which you reacted to is over. So I'm not sure that it's a contradiction, but I would have thought it's a point in your favor that this order was given after 4 seconds and the shooting went on either for another 4 seconds or another 8 seconds, or even there were isolated shots after that for a minute. So, but that's the point I would have thought in your favor. But I don't want to unduly shorten your argument, but
No.
it's not necessary to make points that are clear even to some people.
Yes, Chair, and of course, the judgment of an officer calling for ceasefire would be a relevant consideration when you consider the continuation of fire over those calls. Chair, the conclusion by Mr. Derova that he sees associative threat perception is also relevant to your consideration of the proportionality of shots fired at scene 1, because obviously shooting because others are shooting can never be proportional to anything because you haven't perceived a threat. You're not acting then in self or private defense. But Chair, the critical questions that relate to the TRT line is, why do we have 60 TRT officers with R5 rifles with their absolutely devastating ammunition there? Mr. White's conclusion was that it was entirely foreseeable that having 60 guys lined up with R5 rifles, lining them up because of a poor plan, would result in disproportionate force. We know from the evidence that there were members of the SAPs who fired on automatic mode, which is grossly negligent and was acknowledged as such by Mr. Derova. We have the dust curtain that emerges, after which we would submit no shots could be justified because there was no identifiable threat being neutralized. And finally, Chair, we have the expert evidence of Catherine Scott, which found that R5s continued to be fired until more than a minute after the initial volley started. And Chair, this brings to mind two pithy phrases that are in the heads of argument. The first is from the NDP, where it states that the SAPs need to get away from an approach of more police, bigger guns. Mr. Derova said that his advice to the SAPs had been to arm down and smarten up. And what we see in the disproportionate use of force at scene 1 is precisely the need for recommendations from this Commission in that regard.
Further point that arises at this point, and that is Mr. Hendricks's view. Mr. Hendricks's view is that the National Planning Commission is right to say the police have been remilitarized, and that what happened on the 16th of August is indicative of that fact. That if you're going to plan to deal with problems encountered by the POP, and the remedy you devise for the POP people coming under attack is to have a firing line of 60 TRT people with R5s, then Mr. Hendricks says that that's evidence of a military approach, which is anathema into modern concepts of policing and should have had no place in South Africa. We should never have had ever, but certainly after 94, when there was a distinct policy decision to move away from that, that's something that should never have come back. Anyway, that's Mr. Hendricks's point, which is relevant, I would have thought, to this argument. Whether it's correct or not, we'll hear when Mr. Semenya addresses us.
Yes, Chair, it certainly would be relevant and have further support for the submissions. Chair, I don't intend to canvass what is covered in Part 5 of our heads of argument. The same submissions would arise with respect to the use of force at Scene 2 and its excessiveness. Chair, if I can then turn to my final topic, which is the recommendations made. Annexure A to our heads of argument are the recommendations from the commissioners of the Human Rights Commission. I don't intend to spend too long addressing these with you, but essentially it's a human rights-based approach to ensure the progressive strengthening of human rights. So we see socioeconomic concerns being taken into account, the need for psychosocial support, the need for compensation to the victims, and the like. In addition, that findings be made that the right to life, the right to dignity, the right to freedom and security of the person were violated by the SAPs, that in addition the complementary international human rights instruments were contravened. And then, Chair, there are several recommendations proposed that deal with progressive measures to promote this human rights framework, as well as policy reforms within the SAPs, institutional strengthening, and human rights capacity building within that organization. But, Chair, if I can then turn to Annexure B of our heads of argument, which are the proposed recommendations by Gary White. And if I can address in some detail the first, and we would submit one of the most important of these, and that is that he proposes the appointment of what he calls an implementation oversight body. This would be to address a key concern that Mr. White notes at page 2, paragraph 7 of his recommendations, that a key issue of concern will be to ensure that the recommendations made by the Commission to the President and endorsed by the President are in fact implemented by the SAPS and implemented properly and satisfactorily. In light of this, he proposes an implementation oversight body, which of course the exact composition and mandate would be for the Commission to determine, but he suggests that it may have the following characteristics. The implementation oversight body should be time-limited and based on a realistic expectation of the time period required for the SAPS to implement the endorsed recommendations. It should be led by what he's called an oversight commissioner, someone of significant standing, experience, and independence to ensure the compliance of the SAPS and other related actors with the effective and efficient implementation of the endorsed recommendations. It should have both technical policing as well as relevant legal expertise available to it, and there should also be representation on it from civil society organizations focused on human rights, safety and security, policing, the use of force, and the rule of law. This implementation oversight body should report regularly to the Presidency and the Minister of Police and publish these reports to notify the public relating to its progress in the implementation of any of the recommendations from this Commission by and within the SAPS. Chair, Mr. White explains in his recommendations that he has some experience of that body because when the Patton report came out that looked at reform of the Northern Ireland policing service that Mr. White was a part of, it had 175 recommendations to reform policing. And of those recommendations, 172 to 175 required the setting up of what was known as an oversight commission that monitored and ensured compliance with implementing the recommendations made by the Commission. So, Chair, Mr. White concludes that an implementation oversight body is likely to be determinative of the successful implementation by the SAPS of any policing-related endorsed recommendations. It would not only ensure oversight of the implementation process, but provide additional required expertise to the SAPS during the course of the implementation process. It would ensure the expeditious implementation of the Commission's recommendations and ensure effective interventions to improve the policing capabilities of the SAPS, and would ensure that immediate steps to address the operational failures identified at Marikana were taken. Chair, the next section of Mr. White's proposed recommendations deal with practical measures that he proposes should be implemented within the SAPS to address the absence of a culture of accountability within the SAPS. He repeats that he finds the lack of accountability within the SAPS to be a causal driver of the outcome of the operation, as well as something of key concern to him going forward. But he notes that it's simply inappropriate to make one or two simple recommendations to address this, because it really is about organizational cultural change, starting with the leadership, but implementing processes and systems within the SAPS that will ensure accountability. And he explains the premise from which he moves in trying to identify what could help with instilling an accountability-based culture. And it's to say that where there are internal processes that record members' actions contemporaneously and leave them open to scrutiny thereafter, it's likely to create a culture of accountability from one of impunity or indifference. He then sets out several practical recommendations that he suggests could be made. These include the introduction of what he calls decision-making logs that would record planning and operational decisions by those in command of major public order policing operations. They would disclose not only the decision actually made, but also the rationale for that decision and why alternatives that were considered were rejected. He proposes that police officers and police vehicles carry immediately obvious identification numbers, because often the public order uniforms make police officers appear anonymous, and we've seen in the Commission the difficulty of identifying police officers when they're in their full uniform. So both vehicles and uniforms should carry prominent identification numbers so that when something goes wrong, it's possible to identify who was there. He proposes that the SAPS introduce a system to monitor the use of force by members, and this would be all use of force, whether it's firearms or whether it's less lethal measures such as rubber rounds, water cannon, tear gas. He proposes it could even extend to the use of equipment such as batons or handcuffs in the ordinary use in the ordinary course of their patrol duties. He proposes that this be contained in a database that is monitored, and then he speaks of what he calls tracking and trending. So you track and trend officers that seem to be resorting to the use of force on a regular basis, highlighting this to local command for remedial action. He proposes disciplinary codes be introduced that include a duty of supervisors so as to create vicarious liability for the actions of those under the command of supervisory and officer ranks. He proposes that the use of any firearms or ammunition should be able to be forensically matched. He proposes a robust system of accounting for firearms and ammunition issued to individual officers. He proposes that radio transmission be recorded, because the evidence before the Commission has given rise to several disputes and several deficiencies in your ability to make findings because radio transmissions were inaudible or simply not recorded. He then proposes what he calls a post-incident management regime, which on the one hand would deal with resolving the apparent disputes and contradictions between the roles of the SAPs, detectives and crime scene experts, as well as IPID following an operation, while ensuring that any officer's rights are protected in that process, but ensuring that we get the earliest possible securing of the best evidence from an incident. He proposes that SAPS members be properly trained in their obligations when providing evidence, because given the deficiency of the statements we've seen here, Mr. White says that having proper training in how to provide evidence would address what he's seen here with respect to the many instances where members who didn't fire during an operation but were present, where and when other members did use lethal force, provide statements that do no more than simply recording their presence. And he notes that there would therefore be evidence that could come from these members that were present and observed what happened that we haven't seen. He proposes that the tactic of armed police officers forming a baseline during POP operations be urgently reconsidered by the SAPs, because the justification for such tactic is simply difficult to understand and the likely outcome would have been easily anticipated. And he simply says it's not clear to him what this achieves given its incredibly high level of risk. Finally, he notes that all of these recommendations require strong and consistent leadership which sets transparency and accountability as the key objectives for the SAPs. So, Chair, that is the package of what he's called accountability-related recommendations that Mr. White proposes. He then sets out various recommendations that relate very specifically to planning, chiefly a planning model, and the means by which he suggests that a review be undertaken so that a planning model can be developed for public order operations that would cover all of the relevant factors and ensure things that didn't happen in Marikana, such as a challenge process, such as ensuring the input of skilled, expert commanders is all captured and provided. This obviously would require training and investment in the individual police officers. And essentially that planning model would then ensure that the personnel of the SAPs that are involved in planning these operations are selected for the appropriate and required operational roles that they have. They undertake regular and up-to-date training for these roles, and they're then subject to some form of evaluation of their performance in the planning role. Mr. White then sets out intelligence-related recommendations and briefing-related recommendations, as well as those relating to command and control, training, equipment, and resources. But, Chair, in essence, Mr. White has proposed, and the other two policing experts we would submit have proposed very similar interventions that are necessary, and we would encourage and urge the Commission to adopt the detailed and very specific interventions that Mr. White proposes in the recommendations. Chair, those are our submissions.
Yes, thank you. Before you conclude, my colleague, Commissioner Tekosa, wants to ask you a question or two.
Now, bearing in mind your mandate as, in terms of the Constitution, I just want to check. I didn't have opportunity to go through all the pages here. Is there anything right which was done by the police during this whole operation? Is there anything correct which was done? Because if I understand your argument, right from the planning, everything went wrong. Was there anything that was right done by the police?
Please, people who want to talk, just go outside the chamber. We can't have people chattering among themselves, or commenting on questions being asked, answers being given. You have the right to be here to listen, but not to talk and make a noise. What's the answer to that one, Ms.
Chair, the answer
I
is...
imagine getting in Colonel McIntosh to negotiate
Yes,
would
Chair.
be a very good thing they did.
And Chair, let's recall what
Unfortunately,
Mr. White's, the source of the criticism of the SAPS operation, Mr. White's evidence. Mr. White gave all credit to the approach taken by the police on the 14th, on the 15th. He commended the efforts by Major General Mpembe to negotiate with the strikers on the 13th. He commended the efforts of Officer McIntosh to try to negotiate with the police. But once the decision is made at the National Management Forum to go tactical, that is when everything goes wrong. So Commissioner Tekosa, the Human Rights Commission, and Mr. White in particular, has certainly commended several steps taken by the SAPS once they arrived on the scene at Marikana. But once the decision was taken by the National Management Forum, things went badly wrong.
Now, speaking for myself now, I can understand the LRC, they're representing Leningwane, arrested and injured, they're representing their clients and other people. Is there any reason why your criticism is directed exclusively to the police?
Yes, Commissioner Tekosa, and it's addressed in our heads of argument at Part 1, Section 2, commencing at page 15 of our heads of argument. The South African Human Rights Commission participated here, firstly, because it received a complaint about the police. So its constitutional mandate is to respond through investigation to complaints received about human rights violations. Until the police killed people, they hadn't violated...
Sorry to interrupt you. Here, we're not dealing with a complaint of the police. We are investigating the circumstances about all the role players there. I would take it that since you are not representing any one of them, you would assist us also in the part played by other parties in this whole process. Is there any reasons why you were not offering your services insofar as to assist us, for example, NUM?
Commissioner Tekosa, two responses. Firstly, the reason the Human Rights Commission is participating in this process is so as not to duplicate the investigation that it would otherwise have to make into a complaint that it received about the National Commissioner and the police at Marikana. Its mandate is circumscribed by the complaint it receives. Secondly, when the Human Rights Commission approached the chair of this commission to notify it, to request and advise that it sought to participate in this process, it was very clearly set out that the parameters of that participation would be threefold. Firstly, it would focus on the police because that was the nature of the complaint that received it that triggered its participation at all. Secondly, it would look to assist with procedural questions, and we've played that role potentially to the annoyance of the Commission at some point, concerned about the procedures and the process and fairness of the Commission's proceedings. And thirdly, we sought not to duplicate the evidence that the parties before you would be able to provide. So the other teams that are here representing eyewitnesses can provide you with evidence. That is why the Human Rights Commission instead invested its resources in providing you with expert evidence, that of Mr. White, Ms. Scott, and Mr. Degan in particular. Because providing you with that type of expert evidence would not have duplicated the efforts of the parties that were otherwise before you.
colleague Tukota says
Chair,
there's no further questions.
Chair, I do have 2 submissions that I need to make, though.
Well, make your submissions. Before you make your submissions, let me say that you referred again, as you have from time to time, to the suggestion that the Commission has been acting. You're not listening, so I won't carry on here. You referred in the course of your answer to comments that were made from time to time by the Human Rights Commission, suggesting that we were acting unfairly to certain people, procedurally. I just want to say that, and I have said it already this morning, we have tried very, very hard to be fair to everybody. We've received a lot of criticism. Whenever we gave it a ruling, whenever I gave a ruling against one party, that party said I was being unfair. When I then gave a ruling against the opposite party, the next time I was accused of being unfair again. Well, either I was consistently unfair or these allegations cancelled each other out. I like to think the latter. You said you had 2 submissions you wished to make.
Yes, thank you, Chair. The first is to state that I've explained the reasons why we focused on the police. And, Chair, of course, that's not a complete submission without saying focused on the police in Phase 1. The South African Human Rights Commission fully intended, and to the extent that it was able to, given the opportunity that it had, to participate in Phase 2, which relates to the surrounding socio-economic rights questions that arise, that are the underlying causes of the Commission. So certainly with respect to Phase 2, the Human Rights Commission would have looked at all parties. And I think our submissions that we did make on Phase 2 dealt with the conduct of all the role players and stakeholders that could be held responsible for the dire socio-economic circumstances of the communities of Marikana. So focusing only on one party only is a criticism that could only be made with respect to Phase 1, but for the reasons I've given, we respond by saying it is not a legitimate criticism. But, Chair, you've highlighted the question of fairness. If the Commission felt that it would have benefited from the Human Rights Commission somehow assisting it in Phase 1 by looking at the conduct of other parties, it would have been helpful to know that in the 2 years that we've been here, because we would have then been able to make a decision as to how we do that, and if we could extend our mandate, given its limitations and the fact that that is what constrains us constitutionally and legislatively.
Right, okay, your points you made have been noted. Thank you for submissions. And I already indicated earlier what our attitude is in regard to the inputs we've received, not only from the Human Rights Commission, but which we're going to receive from the other parties as well. And what I say still stands. Mr. Bezos, you next. They're waiting for me. They're talking to one another. How many pages did we file? Yeah. Yes, thank you, Mr. Chairman. Yes, thank you. Mr. Chairman, we have filed 300 pages of argument as to what happened, what should not have happened, and what recommendations the Commission should make.
we cannot do justice to the work that we have done on those heads of argument in the time allowed, but nevertheless, we accept it, and I will try and deal with certain matters for an hour, and my colleagues will follow.
Yes, Mr. Bezos, I don't understand your comment about doing justice too. I made it clear from the beginning, I hope, that the parties were expected to produce arguments which would be in writing. And the time for oral hearing is to be devoted not to doing justice in quotation marks to the whole argument, but to highlighting points that are particularly important and answering questions and points that are raised by the commissioners. So I'm sure the time that you've been given will be enough to enable you to do those things.
We'll try our best, Mr. Chairman. There is, however, a matter that I want to raise right away, which I consider of very grave importance to the reputation of the Commission, to the administration of justice in South Africa, and what contribution we can make in order to enhance the reputation. I am concerned particularly, personally, Mr. Chairman, with paragraph 95 of the SAP's heads of argument. Let me read out the paragraph. The position of SAPS in these proceedings, and especially in relation to persons who died as a result of police action, is that their deaths, where evidence is available, occurred in circumstances of self and or private defense, alternatively putative and self-private defense. What this amounts to is a submission made by SAPS that they should be exonerated, completely exonerated, for anything that happened within the terms of reference of the Commission, and more particularly, that they are not responsible in any way to the people who died and members of their family. You'll forgive me, Mr. Chairman, because we actually practiced for many years together, that the reputation of the administration of justice during the apartheid regime was at a very low level as a result of findings of commissions that no one was to blame. May I remind the Commission that it started with Sharpeville in 1960 and finished with the massacres in the Vaal Triangle in the early 90s and before the dawn of democracy in 94. I would submit with the greatest respect that a finding by the Commission that the police are not responsible for any of the deaths will undermine the administration of justice in our country and the rule of law. And I would urge, for the reasons that I am about to give, I'll forget about the heads of argument. I want to tell you why. The police play a very important role in government, and more particularly in a democratic state. I want to quote what Chief Justice Chaskelson of the Constitutional Court said in the Mohammed case versus President of the Republic of South Africa. In a government of laws, existence of the government will be imperiled if it fails to observe the law scrupulously. Government is the potent, omnipresent teacher. For good or for ill, It teaches the whole people by its example. If the government becomes a lawbreaker, it breeds contempt for the law. It invites every man to become a law unto himself. It invites anarchy. I would submit with respect that this is what the police are asking you to find. Yes, there are laws. There are the standing orders, there's a constitution, there's a common law. Experts can say that we mustn't use R5s. We mustn't be trigger happy. We mustn't do this, we mustn't do that. But the legal representatives of the police want you to exonerate the police. Let me rely on the 14 items in the catalogue read to you by our learned friend, Mr. Chaskelson. 14 of them. If, and I know him, he's very careful, he's like his father. I accept that there is substance in the submissions that he made in those 14. In more than half of them, the people who behaved in that manner defeated the ends of justice deliberately. That is a very serious offense.
Attempted to do so.
Beg your pardon?
If what he says is correct, they attempted to do so. Whether they succeeded is a matter to which we do not know the answer.
But an attempt to defeat the ends of justice is defeating the ends of justice, Mr. Chairman. Many a defense is, I didn't intend it. But if you did it...
Mr. Bezos, let's understand each other. Attempting to defeat the ends of justice is a criminal offense. There's no question about that. Whether the ends of justice were in fact defeated by the attempts to which Mr. Chaskelson referred, and whether that in fact amounted to attempts to defeat the ends of justice, matters on which we must keep an open mind to the end. But if he's right, that what the conduct he referred to amounted to attempt to defeat the ends of justice, whether the ends of justice were ultimately defeated is a matter to which we do not yet know the answer. That's the only point I'm putting to you.
Mr. Chairman, let us pose the question. General Annandale chose Lieutenant Colonel Scott to do a plan to control or to manage the gathering of the people at the copy. He, Lieutenant Scott, said that he had never read the standing orders relating to crowds. He was ordered to do the plan by a general. Is the general going to go scot-free for that stupid decision of his? What was Lieutenant Colonel Scott? A man who had been decorated for killing 11 people instead of arresting them. And he was promoted from lieutenant colonel to colonel whilst these proceedings were going on. What image does that give to the administration of justice by an organ that is there to assist justice, to obey law and order? Are you been asked no one to blame. We heard that from Sharpeville to the Val Triangle, where it finished. By the way, as I've said before, Mr. Semenya and I were involved in the last one. Now, I would submit with the greatest respect that it would be completely unacceptable to the people of South Africa that have been following what has been said if the police are said they are not to blame for anything. I saw in their heads of argument, Mr. Chairman, the first paragraph, and I got some pleasure out of it, because they quoted Mr. Cyril Ramaphosa, that many of us are but two other paragraphs, they ask to be absolved. Now, let us examine that, Mr. Chairman. We act for a young man who was killed some distance away from the gap that they say people were afraid that they would be killed. No weapon was found near him. He was fatally shot. There was no razor mark in order to show that he had been influenced by the person that provided the Muti. His grandfather made a statement that he was a worker. He was earning a total of about 6,000 rands a month, but he didn't think that it was enough because there was a family of 6 that he had to support, and that he was the only breadwinner for the whole family, from the grandfather to one of his young children. There is an affidavit to that effect, and that he was shot dead. The experts that we engaged in order to examine the bodies suggest that he could not have moved very far from the spot on which the bullet finished up in his body, and
the other side of the cross.
Now, what evidence is there that the police should be exonerated for his death? He wasn't in the group that they say he was attacked. What they say in their answer to it is a line, or line and a half, that he made common cause with the people that are threatening them. I'll read I'll read it. He's coupled with other four or five people that he was. in paragraph 178, their answer to it, that they want to be absolved. 178, the bodies of members Gobofile, Guelani, Lendikwani, that's our client's grandchild, and B. Nshazi, were found at the back of the kraal. So there's no dispute as to where he was. They were clearly amongst the group of strikers who were attacking the police, or those the police could reasonably have believed were meaning to attack them. There could not have been any innocent individual the attacking group. They all made common cause within Noki's leadership and utterances that were to kill the police. You know, that may look good. Self-defense and private defense. They were very instructive. I have read all of them. They have a common factor. The self-defense was justified because the person that pulled the trigger went into the witness box and I would say that there are no such statements and that no evidence was given is not the fault of the Commission. I submit with respect that the 9 days that the people gathered in Potchefstroom in order to put together Exhibit L should not have produced Exhibit L for the reasons set out by my learned friend, Mr. Chaskelson, but have evidence, statements. The Commission was announced. It would be for the purposes of the Commission. Instead of putting a incomplete and in some instances false document before the Commission, which we took months to examine and to dig out, thanks to the industry of the evidence leaders, where the truth lie and where they lied about things. And then perhaps, if there were sufficient statements of the individuals that pulled the trigger, it may well have been plethora of evidence of self-defense exonerate them. There are none. There were what are called warning statements. Warning statements are taken. You are not obliged to say anything, but if you do, it may be used in evidence against you. Why? Why such statements and not what was expected by the Commission? In the words of the President, here is the evidence of why we shot. We could have examined. We need not have spent months trying to reconstruct Exhibit L. And perhaps it would have been unnecessary to spend a week or two on the evidence of Mr. X. You are not here, Mr. Chairman and members of the Commission, to exculpate nor to convict the police. You are here to advise the President and the people of South Africa and the world at large that the police had done wrong, that the National Prosecuting Authority was doing between 1960 and 1992 by saying that we have seen no